All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When you hear your name, please say present or here. Raise your hand so I can acknowledge you for the record. Calvin Kritz. Harold Dunn. Matthew Gould. Desiree Harris. Dylan Hogan. Mr. Hogan was set for arraignment. A waiver of arraignment was filed and approved, and pretrial has been set for May 10th. Mr. Schmidt. Lanaria Miles. Michael Musselwhite. Ishmael Rodriguez. Ishmael Deshaya Rodriguez. Jason Bearden. I had a note that Mr. Beard may be a few minutes late. We'll recall him. Carlos Gatlin. Hector Hernandez. Leighton Hausch. Tayumika Johnson. Matthew England. Marshall Flores. Alicia Harris. Jaquavian Jackson. Jaquavian Antron Jackson. Jonathan Keenan. I've got Tad Michael Russell, but I have notification that Mr. Russell is incarcerated in the Henderson County Jail. Has been since April 8th. So we may move him to the, we'll take an announcement on him later, but just note that for the record. Sid Hoffpower. Sid Hoffpower. Braxton Henderson. Thanks, sir. Ashley Smith. Justin Smith. Royce White. Royce Latate White. Mr. Hawkins not here yet either. James Johnson. Here. Priscilla Rosales. Ryan Augustine. James Bustamante. Ralph Hanseca. Charles Howard. Shelby Joslin. Dylan Ostrike. Leonard Purley. Jeffrey Viramontes. Christian Russell. Christian Avery Russell. Dustin Hall. Thank you, Mr. Runner. Leland Cashin. Waiver of arraignment filed, approved. Pretrial has been set May 24th. Leland Cashin, May 24th, pretrial. Omar Galan, waiver arraignment filed, granted, pretrial set May 24th. Omar Galan, pretrial May 24th. Billy Jennings, waiver arraignment filed, approved, pretrial set 5/24. Billy Jennings, pretrial 5/24. Seth Atkins. Christopher Gingo. Jordan Manis. Ray Moore Jr. Claude Solis. And the next are the 10 o'clock and the 11 o'clock. Is there anyone who's in the courtroom who expects to be on the docket and I've not called your name? Your name, sir? Lance Glasscock. Are you here for a criminal case? Yes? Yes. Yes, is that Joel Manuel Rodriguez Garcia? I'm sorry, I can't hear you. Yes, that's at 10 o'clock. So I haven't called this case yet because it's not time to call this case. I can't hear a word you're saying. Give me a second and I'll look it up.
Just my approach.
Sure.
This case was dismissed at the behest of the Hampshire County District Attorney's Office.
Okay. That was, yeah. All right, Mr. Glasscock, I show that the DA's office has dismissed your case. You're free to go. If you need a copy of that, you can see the district clerk across the hall. All right, so yes, Mr. Rodriguez's case will be at 10 o'clock with Mr. Essenberg, and then Tavares Dixon will be at 11 o'clock. All right, counsel, do we have anyone that's ready? Mr. Weiner?
Yes, Your Honor. That's the hall.
All right, Dustin Lee Hall, CR 21385. Mr. Hall set for docket call today.
Yes, Your Honor. I spoke. There was a discovery issue that the state has cured this morning, and so I'm going to ask for an additional docket call setting. There's also a disc I need to pick up at the office. We have a plea offer. I need to sit down with the state and go over some mitigating information with them as well once I review the discovery.
Any objection from the state?
No, Your Honor.
30 days sufficient or less?
30 days will be fine, Judge. Where does that put us with your calendar? May 10th.
You have May 10th or May 12th.
May 10th will be great, Judge.
All right, Mr. Hall, court's going to reset you for an additional docket call on May 10th. Once you sign and get the yellow copy, you're free to go.
Thank you, sir.
You may. Your name, sir?
Harold Dunn Jr.
Harold Dunn, Jr. Yes, thank you, Mr. Weiner.
First page, second case, Your Honor.
Okay, did you file a notice of appearance or letter of
I did.
representation? All right, I don't have you on my.
See, I e-filed it back in February, actually. I can provide you a copy of the letter.
No, I see it here. They just didn't add you into the system.
Okay.
Thank you, Mr. Burns.
Thank you.
All right, Harold Dunn Jr. You'll come up, sir, to the middle podium. All right, this is Harold Wilmer Dunn Jr., and we're set for arraignment. If you had a chance to go over the indictment with Mr. Dunn.
I have, Your Honor. We would waive reading. We would admit that he is the same person charged in the indictment and would enter a plea of not guilty.
Thank you, Mr. Burns. The court will find that Mr. Dunn has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record, and we will set this matter for pretrial. Are you available on May 10th or 12th?
12th would be better for me, Your Honor.
All right, Mr. Dunn, the court's going to set you for pretrial on May 12th. That will be at 9 a.m. Once you sign this notice of setting with Mr. Burns and you get the yellow copy, I need you to report to the pretrial release department so you can sign your conditions of pretrial release. These are going to be conditions that you must comply with. If you violate any of the conditions, the court can revoke your bail and put you back in jail. Okay?
Okay.
All right, so once you sign the yellow copy, you can see Officer Matura here, and she'll give you more information. Thank you, Ms. Burns.
Thank you.
Mr. Schmidt, you ready? Yes, sir. You ready on first?
I'm ready on online, but here I'm on to.
Ryan Adam Augustine, CR 21276. Augustine is set for docket call today.
That's correct, Judge. We received the best offer from the state, and the client rejects that offer and asks that the matter be set for jury trial.
What's the offer that Mr. Augustine rejected?
3 TDC.
All right, and Mr. Augustine realizes and understands that if he wishes to accept that later, the court may not allow him to do so once he requests a trial.
Yes, sir.
All right, Mr. Augustine, the court is going to set you for jury selection. We're going to begin that on Monday, May 2nd. And you're to report to the courthouse here right when you enter the door. I'll have a staff member there. They'll assist you with paperwork. You will not go to trial on May 2nd. However, you will receive a notice of setting with your new date. And you'll continue to do that until your case is reached for trial. Mr. Smith's not going to be required to be here because your case won't be liable for trial. But once the case gets in the top 10 or so, then he'll be required to be here and y'all can get ready for trial. Okay?
Yes, sir.
Once you sign and get the yellow copy, you're free to go. James Bustamante. Mr. Burns, you're going to have to move out of the way. All right, this is CR 219, CR 21281, State versus James Daniel Bustamante, set for docket call.
That's correct, Judge. We're still working with the VA and Mr. Bustamante. I'd ask for an additional docket call so we can continue to work with the VA out of Tarrant County.
Where are we on that? We've been doing this for quite a while. Are we likely to get some kind of resolution with the VA so that we can make a decision on the case?
I think we will, Judge. I think ultimately what we were doing is obviously me and Mr. Woodwhite could discuss the underlying issues. I can relate to the court that Mr. Bustamante had some issues getting back into the VA system because of the COVID issues. But it's my understanding based on my discussions with him that he is actively being seen. And what we want to do is we want to provide records to the DA's office so they can see basically what that is. And that really is the hiccup.
Mr. Schmidt is remaining in contact with Mr. Bustamante, the VA's office and the DA's office. I believe they are making progress. State is comfortable with allowing this to proceed for a while, make sure that he is continuing to do that. I have no doubt we will reach a resolution on this. We just need to allow him to get the help that he needs such that we can reach that point.
All right, 30 days or more.
Or if I could get it.
Any opposition?
No, Your Honor.
Remind me your June schedule, 14, 16.
You said 14th and 16th? I think 16th. I don't think I have anything set in June yet that I recall.
16.
16th.
All right, Mr. Bustamante, the court's going to set you for June 16th at 9 a.m. Once you sign and get the yellow copy, you're free to go.
Thank you, sir.
Ralph Hanselka. Mr. Hanselka is set for a docket call in each of his cases.
Can we approach this?
You may. All right, court has Mr. Hanselka set for docket calls. My understanding that there's a request by both the state and the defense for the court to reset for an additional docket call to give the state and defense time to continue to work this case out.
Correct.
All right, court will reset Mr. Hanselka. Be available on May 10th or 12th, Mr. Schmidt.
10th, Judge.
All right, Mr. Hanselka, court resets your docket call to May 10th. Once you sign and get the yellow copy, you're free to go, sir. Charles Howard, CR 2176, CR 21386. All right, Mr. Howard set for docket call.
That's correct, Judge. I've been negotiating with the state. They have made a new offer as of yesterday. I'd asked for one more docket call so we can work that out.
Less than more time based on your new offer.
Yes, Judge, Mr. Schmidt and I have been in discussions on this. I think we're very close to resolution. I believe one more should do it for us.
All right, court will reset Mr. Howard for an additional docket call on May 10th. Mr. Howard, once you sign and get the yellow copy, you're free to go. Shelby Joslin.
Not we, but
Oh, I know. All right, Miss Joslin, this is CR 2126. She is set for a docket call today.
it's correct, Judge. We received an offer from the state which we intend to accept. We'd ask that this be set for a plea to that 5-10 date.
All right, court sets Miss Joslin to enter a plea before the court on May 10th at 9 a.m. Miss Joslin, once you sign, get the yellow copy, you're free to go. Dylan Ostrike. CR 2223. Mr. Ostrike is set for pretrial.
That's correct, Judge. We received the discovery last week. We need another pretrial for that case. I don't know if there's any more coming, but
Judge, we've had issues with several of our agencies' discovery that I believe we are caught up on as far as we're aware, rectifying the situation. But we do have several cases that were impacted by improper formatting. And so if Mr. Schmidt needs an additional setting after reviewing what he has, we wouldn't object.
All right, court will reset Mr. Ostrike for an additional pretrial to May 10th, 9 a.m. Once you get the yellow copy, you're free to go. Leonard Purley. All right, Mr. Purley is set for docket call CR 21234.
that's correct, Judge. I've been in discussions with Mr. Woodwipe on Mr. Purley's case. I think we're about a millimeter away from a resolution on his case. And ultimately, I believe that it may require some money. We'd ask for additional docket call. I think that we're gonna have it resolved.
Surely Mr. Purley is also delinquent on his pretrial release fees.
Can I have it till the end of the day?
Sir?
Can I have till the end of the day?
If you're delinquent $300, you can pay up all $300 by the end of the day.
If I can pay half.
Pay half. Well, I've ordered you to pay 50 a month. How many months does it take to get to a $300 loan?
That's slow.
I understand. There's gonna be no work if you're sitting in jail.
That's right.
You'll be doing the county work. You understand? I'm gonna order you to make $100 payment by the end of the day.
Yes, sir.
Okay? All right, court will reset Mr. Purley for a docket call on May 10th at 9 a.m. Is Jeffrey Viramontes here? Viramontes?
Judge, if the court will indulge me, Mr. Viramontes, I saw him yesterday, so I'll leave and track him down.
Is that all you have to, Mr. Viramontes?
Yes, sir.
Do you have anyone else that's ready? Hero.
Yes, Your Honor.
Christian Russell, CR 2361.
Does he go there or not?
Yeah, he'll go right there at that podium. All right, Mr. Shapiro, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is Christian Avery Russell, is that right?
Yes, sir.
And Mr. Russell, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Todd Shapiro. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. Shapiro, do you believe your client to be competent today?
Yes, Your Honor.
And have you explained to him his legal rights?
Yes, Your Honor.
And do you believe he understands them?
Yes, Your Honor.
Mr. Russell, I see here that you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 2, greater than or equal to 1 gram but less than 4 grams. A third-degree felony in the state of Texas carries a range of punishment, if convicted and sentenced, to not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and an optional fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, Your Honor.
I see that also you want to enter into a plea agreement with the state wherein the state would recommend that your guilt be deferred and that you be placed on 5 years of community supervision with a $3,000 fine plus court costs, restitution, and reimbursement fees. And the state would be dismissing an unfiled possession charge. Is that your understanding of the plea?
Yes, Your Honor.
You understand if the court approves this today and places you on community supervision, if later you violate the terms and condition of your community supervision and the state proves that to the court in a separate hearing, court could revoke your community supervision, could adjudicate your guilt, that means convict you, and the court could assess your punishment anywhere between that 2-year to 10-year range.
Yes, Your Honor.
Understanding all of that, do you still wish to go forward?
Yes, Your Honor.
All right, at this time, Mr. Russell, how do you plead to possession of a controlled substance in penalty group 2 greater than or equal to 1 gram, less than 4 grams?
Guilty.
Are you pleading guilty because you are guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty?
No, Your Honor.
All right, the court accepts the defendant's plea of guilt. Mr. Shapiro, any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor, we would rest in close.
from the defense?
No, Your Honor. Rest in close.
I'm going to review the evidence. All right, court's reviewed the evidence. I do find that there's sufficient evidence to convict Mr. Russell of the offense. Court will follow the plea agreement in this case. Court hereby defers a finding of guilt, places Mr. Russell on 5 years community supervision, orders him to pay a $3,000 fine, $180 restitution, $105 reimbursement fees, $290 court costs. And the court takes into consideration under section 1245 F19 321, unindicted possession of controlled substance, penalty group 1A. Mr. Russell, you're hereby remanded to the remained to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward up here with the bailiff to be fingerprinted. After that time, you speak with Officer Mature and she'll give you more information about your probation. You can come on.
Yes, sir.
Thank you, sir.
Thank you, Your Honor. Big excuse.
Thank you, Mr. Sgro. Appreciate you, sir. Mr. Estrada?
Yes, we have Mr. Braxton Henderson, 21002, Judge.
Mr. Henderson, if you'll come forward, sir, to the middle podium. All right, cause number CR 21289. Mr. Henderson is set for pretrial, I believe.
Yes, Your Honor. We are asking for an additional pretrial on this matter. We recently filed a blood discovery motion. I would like to have the state have an opportunity to review that. This discovery motion is requested by our toxicologist that we have I'm sorry, I lost the words, Judge. We've notified the court of our expert. We've designated as an expert. Dr. Bobs is requesting this blood discovery through the Southwestern Institute of Forensic Sciences, Judge. It's a standard blood discovery that's used it's a standing order that's used by Harris County. Judge. Dr. Bobs is based out of Houston. I don't believe that the state will have an objection once they have an opportunity to review that. And that once you sign that order, Judge, it'll be submitted to Southwestern Institute for them to comply and provide that to our toxicologist. In addition, we've designated a forensic pathologist as an expert as well. Some recent autopsy photos were released from the district attorney's office that I need to share with our forensic pathologist in this matter.
Your Honor, state's unopposed to another pretrial setting to resolve these issues.
Do you know how long you've already filed the blood discovery motion?
Yes, it's been filed, and I just want to give the state opportunity to review it, and I do not believe there'll be any objections. It's a standing order in Harris County, Judge.
And Judge,
Is there certainly the time you would like?
I'm gonna just ask for the standard 30 days. We received it last night after hours. I haven't had time to review it or to talk to Swifts about it, but we can try to get that accomplished in 30 days.
Just going forward, we got to understand that the code says that all pretrial motions need to be filed 7 days prior to the pretrial setting, so we don't run up on this issue.
Yes, and Dr. Bobs requested this last week, and after he's reviewed the initial autopsy report. So he'd been reviewing the initial autopsy. This is his additional request.
All right, are you available on May 10th or 12th?
Judge, I was gonna ask for 60 days. If there's no objections, if we can just submit it by agreement for the court to sign it. That way we don't need to be back in 30 days.
Judge, I'm not opposed to that. I can just forward for your signature and indicate our agreement when we reach that point.
Just understand that resetting 60 days is going to push us further off if he requests a trial.
Yes, Your Honor.
All right, I'm going to note that for the docket. So are you available June 14th or 16th?
I can look at my calendar. June 14th works,
June
Judge.
14th. All right, Mr. Henderson, the court's going to reset you for pretrial on June 14th. Once you sign and get the yellow copy with Mr. Estrada, then you're free to go.
Is the reset order?
Has he signed it?
He has.
So yeah, just
You want me to just
yeah,
let
you
the
need
date?
to sign a date, everything on the bottom, and then leave the black copy here, and the yellow copy goes in.
Thank you.
And there's nothing for me to sign.
Okay.
just grab that and use that because it's always hard to watch that podium. Mr. Schmidt, are you ready on Viramontes?
Yeah, not Viramontes, Judge. I surrendered the podium too soon. Miss Desiree Harris set for arraignment.
Desiree Harris. I'm sorry. What we said. Okay. All right, this is CR 2223, State versus Desiree Sunshine Harris set for arraignment. Go ahead, Mr. Schmidt.
Judge, we've received a copy of the indictment. Miss Harris's name is spelled out correctly. She understands what she's charged with. We enter a plea of not guilty. Wait for reading as to be set for pretrial.
All right, court will find that Ms. Harris has waived the formal requirements of arraignment. The court will enter her plea of not guilty into the record, and the court will set Ms. Harris for pretrial on May 10th at 9 a.m. Ms. Harris, once you sign and get the yellow copy, then I need you to report to pretrial services so you can sign your pretrial release. Oh, she's already done that? Okay, once you sign, get the yellow copy, you're free to go.
Thank you, Mr. Smith. Thank you, Your Honor.
Screen ready? How we feeling? Any good news?
No good news yet.
No bad news?
No.
Who are you ready on? You ready? You got
I'm ready on both, Judge.
Ashley Smith and Justin. Wow. Ashley Smith, CR 21341. All right, we're set for docket call today.
Judge, when we were here last, I requested leave if necessary to file any additional or any pretrial motions. I did file one yesterday morning, although I was looking through my emails. It doesn't appear the clerk has accepted it at this time. It's related to the location of the blood draw taken from Ms. Smith. I know it was a little late. However, I haven't been in the office much over the last month. But if we could set this for, I guess it's set for a docket call today. If we could set it for another docket call, I can visit with the state. Perhaps we could work that issue out without having to have a hearing on it.
State.
Judge, I haven't seen the motion that Mr. Green is referring to, but I don't have an objection to resetting, so we can do that, speak with the defense, see if we can work out something on that if we try to resolve that without a hearing and then maybe resolve the case.
May 10th or 12th.
May 10th, Your Honor.
All right, court will set Ms. Smith for docket call on May 10th at 9 a.m. Ms. Smith, once you sign and get the yellow copy, you're free to go. Justin Smith, CR 21370. Mr. Smith is set for pretrial.
Judge, we have no pretrial issues to raise.
All right, there being no pretrial issues, court will set this matter for docket call. We'll set that May 10th at 9 a.m. Once you sign and get the other copy, Mr. Smith, you're free to go.
Judge, that's all my business, ma'am. Excuse.
Yeah, just one second. CR 20191, and I have a request to amend your conditions of community supervision. Here, I'll tell you what, come on around. Come on up here. I know that's hard to see over here. All right, Mr. Rosales, I see here that there's a request to extend your probationary period for an additional 3 months. Looks like you were set to get off probation here in 3 days, and you're asking to have it extended until July 14th. It looks like there's a couple things that you still lack on complying with all of your conditions. And do you believe that if I extend it for 3 months, you'll be able to complete everything you're supposed to do?
Yes, I have it set up for my kids in lunch.
Okay. All right. All right. And so, Ms. Rosales, I just have to ask, has anyone threatened, force, or pressured you to make you feel like you had to extend your probation? This is to your benefit, right?
Yeah.
Okay. All right. All right. Court will approve the amendment to the conditions of community supervision. I'll waive the probationary fees during the extension period. I'll waive the UA fees during your extension. And we will extend you for an additional 3 months with your new deadline expiration to be July 14th of 22. I will waive the repeat offenders course, and your ignition interlock is also waived. You're welcome. All right, so I've signed this. Let's come over here and see Ms. Burns. You're welcome. I didn't see her on my document. The other front page. Where's your second? I guess. I was kind of waiting until they popped in. That was crits, right? Calvin Kritz, CR 22-9. All right, Mr. Chris, I find that you have requested a court-appointed attorney.
Yes, sir.
The court has reviewed your paperwork, and unfortunately, due to the number of assets that you have, you do not meet the law for indigency. So what I'm going to do is I'm going to reset your case for an additional 30 days to give you time to go out, and you can either hire an attorney or you can represent yourself, which I would not advise you to do. This is a state jail felony offense, possession of controlled substance. If you were convicted of this offense and sentenced, your punishment range could go from probation all the way up to 6 months, up to 2 years, day for day in a state jail prison. Okay. So due to your assets, your home ownership, you're not going to qualify. So you need to go out and decide if you're going to hire an attorney to represent you or if you're going to represent yourself. You understand?
Yes, sir.
All right, so I'm going to have Deputy McLeish, she's got a form for you here. I'm going to have you sign this, and it's got your reset date on it of May 10th. Mr. White, are you ready?
Yes, sir, I am.
I'm just kind of waiting to see. I may have to interrupt you because I've got a OCA interpreter scheduled for 10 o'clock, but we'll just get going on yours. And whatever the court needs. I don't see that person here yet. So. Who are you ready on?
I've got a couple of just resets, Your Honor. We can begin with Mr. Atkins.
Seth Atkins, CR 22-1. All right, Mr. Atkins is set for pretrial.
Your Honor, we're going to ask the court to move this over to docket call.
All right. There being no pretrial motions, court sets Mr. Atkins then for docket call. Are you available on May 10th or 12th?
Let's do May 12th, Your Honor.
All right, Mr. Atkins, May 12th, 9 a.m. Once you sign and get the yellow copy, you're free to go. Sir.
Actually, hold on just a second, if you don't mind, Your Honor. I need something scheduled. Just recall something.
Is Sid Hoffpower here?
Yes.
Where you at? Okay. Got two people on my page. Okay, that's fine. That's fine. Okay. All right, who's next, Mr. White?
Mr.
Oh, yeah, you're free to go.
Mr. Gingo.
Christopher Gingo, CR 22-21. Mr. Gingo set for pretrial.
Your Honor, I filed a motion for discovery for some blood evidence. Ms. Heisel has already looked into that with the DPS, and I believe she's just waiting for them to send it to her. So if we could have another pretrial.
That's correct, Your Honor. Yesterday, they asked me for some clarifications, and I responded, so I expect that back in the next week or two.
All right, court will reset Mr. Gingo for pretrial on May 12th at 9 a.m. Mr. Gingo, once you sign and get the yellow copy, then I need you to go and sign your conditions of pretrial release. These are going to be conditions that you have to comply with that will be attached to your bail in this case. If you have any violations, the court could revoke your bail and put you back in jail. Okay. Yeah, that's fine. Yeah, he'd come on through. Just go around that way because we got a pair of headphones. Aaron, will you move those headphones up behind the computer so nobody inadvertently doesn't see that and trip through it? What you got next?
I believe we got some pleas.
All right, I'll tell you what, let me interrupt you there. I just saw the interpreter come in and then we'll get you right back up. Don't let me forget, okay? All right, Mr. Rodriguez. Mr. Rodriguez, if you'll go to the middle podium.
Good morning, Your Honor.
Good morning, Maria. How are you?
I'm doing very well, sir. Thank you very much.
All right, I believe I'm set up on my end, and this is Mr. Joel Manuel Rodriguez Garcia.
That's correct, Your Honor.
Hello, Mr. Essenberg.
Good morning, Your Honor.
I see that you're in your vehicle. I'm going to give you a heads up. Next time I need you to have your jacket on if you're going to appear in court, just like if you were here in person. That's okay. I'm not going to make you do it. I'm not going to make you do it right.
I just pulled in the parking garage, Judge, so I just hadn't had an opportunity to do that.
I understand.
But certainly I understand, and I will, I anticipate that next time I see you, Judge, we will be in person, prepared to plead this case. I've spoken with the prosecutor. We've been offered a plea bargain. I anticipate that the plea bargain, having discussed it with my client, that we will accept. But I need to have a meeting with an immigration attorney to discuss the immigration consequences of the plea before we go ahead and enter the plea. But beyond that, I anticipate that we are ready to set this for a plea.
Okay. All right. Give me just 1 second. And Maria, I'm sorry, we kind of jumped the gun here. Let me go ahead and have you identify yourself for the record, and I'll place you under oath. All right. Ma'am, do you swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? Thank you. All right. And so, Mr. Esberg, do you have any contested pretrial motions at this time that need to be
We do
scheduled?
not. No, we do not, Your Honor.
All right. So what I would typically do is set this case in for docket call. Once we get past, since there's no contested pretrial issues, then I would set it for docket call. And that would be the time that the court would expect the defendant in the state to finalize if there's going to be an agreement, resolution to the case, or if there's going to be a request for a bench trial or a jury trial. So what I would do now is I would set it out usually around 30 days to give y'all time to work. So if you have your calendar there with you, if you would look at May 10th or 12th, and tell me if one of those is better than the other for you. And if you need more time, let me know.
Give me just a second, Judge. My calendar and my phone are in the same place, so I'll do that right now.
Yes, sir.
Judge, May 11th, I anticipate would be just fine.
Well, it's May 10th or 12th.
Oh, I apologize.
Okay.
Look at that again then. Judge, I have a setting in Denton County on the 10th and in Ellis County on the 12th.
Are those morning or afternoon settings?
They're both morning settings, Your Honor. Such that I have no settings in the afternoon on either one of those days if the court's docket extends to the afternoon.
I typically do my jail docket in the afternoon. What about May 24th?
Nothing at all set that day, Judge. That would be an even better day.
If this case does end in a resolution to some kind of plea, do we anticipate that it would be for probation or for time?
Probation.
For probation, Your Honor.
What we're anticipating at this point.
All right, then, Ms. Villiers, will you tell me if there's any availability for an interpreter on May 24th? Thank you. Yes, ma'am, please. Yes, ma'am. Okay, let's set it for May 24th, and we'll also set it again for 10 a.m. That'll give me
That's
time.
perfect, Your Honor.
It'll give me time to call on morning docket. All right, so the court's going to order Mr. Rodriguez to appear before the court May 24th at 10 a.m. And if you can ask him if he has any questions or if there's anything he doesn't understand.
You want me to ask him, Judge, or the interpreter to ask?
The interpreter.
Okay.
No.
Okay, all right, so once Mr. Rodriguez signs his notice of setting and gets the yellow copy, then he is free to go.
Thank you, Your Honor. I appreciate your time.
Yes, thank you, Mr. Essenberg.
May I be excused, Your Honor?
Yes, sir, you may.
Have a good day, Judge.
Thank you. Mr. Rodriguez, you're free to go. Thank you, ma'am. I appreciate your help this morning. Yes, ma'am. You have a great day. No problem at all. I appreciate it. All right. We had no one on. Please, is he floating out? So he might get back in.
I'm sorry.
Nolan White.
Were you asking? Oh, Mr.
Yeah, we had started him. I had to stop him for this, and then he said he had a couple of things ready. I'm sorry, Mr. White. I didn't know if you wanted to go ahead and keep working out there. If you wanted.
No, we're good, Your Honor.
Okay. Jordan Manis. All right, Mr. Manis. This is cause number CR 2397. Mr. Manis, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, Your Honor. All right, let me put your hand down. Your name is Jordan Wyatt Manis, is that correct? Yes, Your Honor. And, sir, are you a United States citizen? Yes, Your Honor. And do you read, write, and speak English? Yes, Your Honor. Have you ever been diagnosed with any type of mental condition? No, sir. In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you? Yes, Your Honor. Feel like you've had enough time to discuss your case with him, have all your legal questions answered? Yes, sir. Anything about this paperwork that you've read and signed today that you do not understand? Yes, sir. Mr. White, do you believe your client to be competent today?
Your Honor, I believe that Mr. Manis is competent, understands the proceedings that are pending against him here today. Before the court, we have executed a set of waivers. I believe that he's executed those waivers knowingly, intelligently, and voluntarily. If the court chooses to go along with the plea agreement, it will be for a deferred adjudication. I've explained the advantages and disadvantages of entering into such an agreement to Mr. Manis. Most notably, if he violates any term or condition, the court will hold a hearing, determine whether or not he violated. If the court finds that he violated, he can be sentenced up to 20 years and a fine not to exceed $10,000.
Thank you, Mr. White. All right, Mr. Manis, I see that you have been indicted with the second-degree felony offense of possession of a controlled substance in penalty group 2, greater than or equal to 4 grams, but less than 400 grams. If you were convicted and sentenced on a second-degree felony offense such as this, the range of punishment would have to be between the minimum 2 years to the maximum 20 years confinement in the Texas Department of Criminal Justice Institutional Division, and a fine not to exceed, an optional fine not to exceed $10,000. Do you understand that full range of punishment? Yes, sir. plea agreement, as Mr. White's already mentioned, is that the state would recommend that the court not convict you today, but the court defer a finding of guilt, that the court accept your plea, that the court assess your punishment at 5 years community supervision at this time, place you on community supervision, order you to pay a $2,500 fine plus court costs, restitution, and then the state would be asking the court to dismiss an unfiled possession of marijuana case that they have pending against you. You understand that plea agreement? You understand that if I approve this and I place you on deferred, that once you're on deferred community supervision, if you violate any of the terms and condition of that community supervision, the state can file a motion to adjudicate you. That means to convict you of the offense. The court could revoke your community supervision, and the court, upon reviewing the evidence, if the court finds that you violate any one of those, the court could revoke your community supervision and assess your punishment anywhere from that minimum 2 years to that maximum 20 years. You understand that? So understanding the full range of punishment, understanding the plea agreement, you still wish to go forward? All right. Mr. Manis, how do you plead to possession of a controlled substance in penalty group 2 greater than or equal to 4 grams, less than 400 grams?
No contest.
No contest. And are you pleading no contest to that offense in understanding that a plea of no contest is treated legally the same as a plea of guilty? All right, court will accept the defendant's plea of no contest. And Mr. White, is there any objection to the state's evidence?
Objection.
All right, state's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Now I show that on the judgment, it says guilty.
Yes, Your Honor, that's not something that we had discussed previously, but the state has no objection to a no contest plea.
All right, so I'm gonna mark through that. All right, court's reviewed the evidence. I find sufficient evidence to convict Mr. Manis of this offense. Court will follow the plea agreement in this case. Court hereby defers a finding of guilt, places Mr. Manis on 5 years community supervision, orders him to pay a $2,500 fine, $180 restitution, $90 reimbursement fees, and $290 court costs. And the court takes into consideration M19-476, possession of marijuana less than 2 ounces. Mr. Manis, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. And whenever you step forward, with Deputy McLeish to be fingerprinted. After that time, report to the probation officers. Claude Solis. All right, Mr. Solis, this is cause number CR 21-246. Sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Solis, are you a United States citizen?
Yes.
Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you? Like you've had enough time to discuss your case with him, have all your legal questions answered? Anything about the paperwork that you've read, signed today that you do not understand? Mr. White, do you believe Mr. Solis to be competent today? And have you explained to him the advantages and disadvantages of a deferred adjudication plea?
I have, Your Honor, and I do believe he's competent.
All right, Mr. Solis, I see that you are indicted with a state jail felony offense of taking certain wildlife resources without consent. A state jail felony carries a range of punishment of not less than 6 months or more than 2 years confinement in the state jail division of TDC, and also carries an optional fine not to exceed $10,000. Do you understand that full range of punishment? All right, and Mr. Solis, I see that there's a plea agreement in this case wherein the state would be recommending that the court defer a finding of guilt upon your plea of guilty, place you on 3 years community supervision, order you to pay a $3,500 fine plus restitution.
Your Honor, I believe the fine's 2,000.
Yeah, well, it says 3,500 on in the order. It says 3,500 in one spot and 2,000 in the other. 2,000.
Yeah, it's 2,000.
Front page of judgment. This is terms of the plea bargain.
Oh, yes.
3,500 there. Any objection from the state?
No, Your Honor.
All right, correction, Mr. Solis, the fine will be $2,000 plus court costs, reimbursement fees. Is that your understanding of the plea agreement, sir? You have to say yes or no, so my court order could take it down, okay? All right. All right, so Mr. Solis, then how do you plead to taking certain wildlife resources without consent? Guilty, not guilty, no contest? Guilty? And Mr. Solis, are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty today? All right, court accepts Mr. Solis's plea of guilt. Mr. White, any objection to state's evidence?
No objection.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, just for the record, Mr. Solis, when he was arrested on 2 charges. The tampering with evidence charge is not reflected in the judgment because it was outright declined by our office at intake. But just wanted to make the court aware and Mr. Solis aware that the district attorney's office has already resolved that charge.
All right, and I want to also inquire, were there any weapons seized as part of this offense? And if so, is there an agreement on those?
May we approach?
Further from the offense?
No, sir.
court's reviewed the evidence and I find sufficient evidence to convict Mr. Solis of this offense. Court will follow the plea agreement in this case. Court hereby defers a finding of guilt, places the defendant on 3 years community supervision, orders him to pay a $2,000 fine, $290 court cost, $90 reimbursement fees. And Mr. Solis, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted with Deputy McLeish. After that time, you'll report to the probation officers. Over here to my right, your left. You may. All right, this is Safetex versus Ray Moore Jr., cause number CR 21230. Mr. Moore, sir, if you'll raise your right hand, I'm going to place you under oath. If you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
No.
All right. Mr. Moore, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Correct.
Feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes.
Anything about this paperwork you signed today, Mr. Moore, that you don't understand?
I don't think so.
Mr. White, do you believe Mr. Moore to be competent today? Have you explained to him advantages and disadvantages of a deferred and all of his legal rights in this paperwork today?
I do believe he's competent, and I have explained everything and satisfied that he's waived those rights, knowing intelligently and voluntarily.
All right, Mr. Moore, you are indicted with a second-degree felony offense of aggravated assault with a deadly weapon. That carries a range of punishment of not less than 2 years or more than 20 years confinement in TDC if you're convicted of that offense. I see that there is a plea agreement in your case. Can I have counsel approach real quick? All right, Mr. Moore, if you are convicted of that offense, then the punishment range is minimum 2 years to a maximum 20 years and a fine not to exceed $10,000. And I see the plea agreement is that the state's recommending to the court that I hear your plea of guilt, that I accept your plea of guilt, but that I not convict you today, but that I defer a finding of guilt, place you on community supervision for 3 years, have you pay a $1,000 fine, $290 court cost, $35 reimbursement fees, and the DA's office is going to dismiss a criminal trespass of a habitation and a terroristic threat. They're going to dispose of those two cases with your plea today. Is that your understanding of the plea agreement in this case? All right. So, Mr. Moore, understanding both the plea agreement and the range of punishment. So I'm going to ask you, how do you plead to aggravated assault with a deadly weapon?
Guilty.
And are you pleading guilty, Mr. Moore, because you're guilty of committing that crime?
I didn't point the gun, but yeah, I'm guilty.
Is there, I haven't read the evidence yet. Is there going to be sufficient evidence to convict Mr. Moore despite his statement that he didn't point the gun? Okay. All right, and Mr. Moore, has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty today?
Negative.
All right, and Mr. White, is there any objection? The court's going to accept Mr. Moore's plea of guilty at this time. Mr. White, any objection to the state's evidence? No objection. All right, there being no objection, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, there is a victim impact statement that was forwarded to the court in conjunction with this plea. We would ask that you take that under advisement at this time.
Ms. Heisel, I see that there's a claim of financial loss by the victim. Has this been addressed by your office? You can come look at this if you want.
Judge, I see the claim. Let me look at our notes and see if that has been. Judge, I can check. I don't have any notes on file as to whether that has been requested at this time or not. I know that victim impact statement, I believe, was returned a fair while ago. Inquire. Judge, I've not received a response from Ms. Cheney, but I am looking in our victim portal and I don't know any requests for restitution returned by the victim. That may be informational for the court more so than a request for restitution because I don't see that additional document in the notes or in the case.
All right, the court's reviewed the evidence. The court will follow the plea agreement on the recommendation of the state. Court will defer a finding of guilt for Mr. Moore, place him on deferred community supervision for 3 years, order him to pay a $1,000 fine, court cost of $290, reimbursement fees of $35. Court dismisses DA 2021-351 criminal trespass and DA 2021-352 terroristic threat. Mr. Moore, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with the deputy. After that time, you're to report to the probation officer over here to your left. I think that's all I had. That's all I should. That statement. Just how they see you. Appreciate you. I'll be gone. Judge Rapp will be here. Great. I think so. Mr. Adams, are you ready?
Yes, sir.
Are you ready on, sir? Everyone except? Everyone except 9 o'clock. Jason Bearden, CR 21-278. Mr. Bearden is set for pretrial today.
Yes, Your Honor. On behalf of Mr. Bearden, we don't have any pretrial issues to bring to the court's attention today. In fact, I think we have a tentative plea agreement worked out. That plea agreement will be contingent upon Mr. Bearden completing the inpatient drug or narcotics rehabilitation program that he is currently attending in Bonham. Mr. Bearden advises me that he's got another 2 to 3 weeks remaining in his program. Upon completion of, if he completes the program, that will result in one particular plea offer. If he doesn't, then another one will come into play. So I think what we'd ask the court to do is reset him for a plea hearing about 4 to 6 weeks out, see where we are at that time, or a docket call.
All right. We'll set it for docket call either May 10th or 12th.
May 10 would be preferable.
May 10th?
Yes.
All right, Mr. Bearden, court sets you for docket call on May 10th at 9 a.m. Once you sign and get the yellow copy, you're free to go, sir.
Thank you, sir.
All right. Carlos Gallen, CR 21-288. All right, Mr. Gallen, set for docket call.
Yes, Your Honor. On behalf of Mr. Gatlin, there is some video footage awaiting me at the district attorney's office regarding Mr. Gatlin's case. I believe it is video footage that I don't have, that I need to view in order to determine whether or not a suppression issue is in play here. We have.
Is this new video footage?
It is video footage that up to this point has not been, it was either corrupted or incompatible with the computer system that I use. I brought this to the district attorney's office's attention, and it's been waiting for me for about 10 days or so.
It was recently copied from Mr. Adams, Judge.
All right, court's going to reset Mr. Gatlin for docket call on May 10th. Once you sign and get the yellow copy, you're free to go, Mr. Gatlin. Hector Hernandez, CR 17459. Yeah, you can go ahead and start making your way up, sir. All right, Mr. Hernandez is set for docket call today, CR 17459.
Yes, Your Honor. We need a trial setting, Your Honor. I don't think this is going to be resolved with a plea agreement.
Was an offer made and rejected?
Correct.
And what was that offer?
18 months state jail.
And Mr. Hernandez understands that the court's not going to allow him to accept an 18-month sentence after today.
Correct.
Okay. All right, Mr. Hernandez, court will set you for jury selection. And let me ask, is that the best offer you are making in this case? I want to make sure that there's no Brooks notices that intend to be filed later. It's going to enhance the punishment range.
Judge, this case is older. It was actually Mr. Cox's. It's neither Ms. Heidel's nor mine. I don't know if we have reviewed it for a better offer.
It's a 5-year-old case, Your Honor.
I'll tell you what, I'll set Mr. Hernandez then for jury selection on Monday, May 2nd. That'll be at 8:30. Mr. Hernandez, you'll report to the courthouse. You won't be up here. You'll be on the second floor. I'll have a member of my staff down there. They'll assist you. Your case will not go to trial on that day, and Mr. Adams will not be required to be here. You'll get a reset notice for your next date, and you'll continue to come until your case is reached for trial. If the defense and state reach an agreement, then if you'll let me know well in advance of trial, then I'll consider it.
Understood.
Once you get the yellow copy, you're free to go. Stop. Leighton House. This is cause number CR 21360. Mr. House, that's docket call.
Yes, Your Honor. We have reached a plea agreement with the district attorney's office, and so we asked the court to set us for a plea hearing.
All right, court will set Mr. House for plea before the court on May 10th at 9 a.m. Mr. House, once you sign and get the yellow copy, you're free to go. Tayumika Johnson. right, it's cause number CR 21296. Ms. Johnson set for pretrial.
Yes, Your Honor, we don't have any pretrial issues to take up this morning. We have reached a plea agreement with the district attorney's office, and so we'd ask the court to set us for a plea hearing.
All right, court will set Ms. Johnson for plea before the court on May 10th at 9 a.m. And there's a delinquency of $260 for Ms. Johnson. I'd like to have that resolved before the court entertains her plea. It's going to have an impact on whether the court accepts her plea or not.
That's all I have. Set 9 o'clock. That's about until
You have what, at 11 o'clock?
Mr. Dixon is set for 11 o'clock.
Okay.
He's on his way from Louisiana.
Yes, sir. Mr. Manning? Sorry.
I have currently before the court, Michael Musselwhite, Ismail Rodriguez for arraignments.
Michael Musselwhite. Call him at the same time. Also want, this is Michael Musselwhite, CR 2240, and Ishmael Rodriguez, if you'll come on up. They'll just both stand right there together, if you don't mind. This is CR 21368. See, both of you gentlemen requested court-appointed attorney. The court has reviewed your information, finds that you are indigent, and the court has appointed Honorable Richard Schmidt to represent each of you. Mr. Musselwhite, you are set for arraignment. Mr. Schmidt, go ahead.
Judge, we received a copy of the indictment. Mr. Musselwhite's name is spelled out correctly in the indictment. We waive formal reading and are plea not guilty, asked to be set for pretrial on that May 10th docket.
All right, court will find Mr. Musselwhite has waived the formal requirements of arraignment. Court will set him for pretrial on May 10th at 9 a.m. Mr. Musselwhite, once you sign the yellow paper, then I need you to report to pretrial release. Sign your conditions of pretrial release. These are going to be conditions that you must comply with to remain out of jail pending trial. You'll ask Mr. Schmidt. He'll take care of all your questions. All right, if you'll step over to the side and let Mr. Rodriguez step up. Mr. Rodriguez is set for status.
Sir. Judge, has Mr. Rodriguez been arraigned on these charges?
Not sure. Let me look this up. Mr. Schmidt, no, Mr. Rodriguez has not. This was a status on to hire an attorney. So the court's reviewed his request, appointed yourself, obviously. So have you had a chance to review the indictment?
I have, Judge. Mr. Rodriguez's name spelled correctly. Wait formal reading.
All right, court will enter Mr. Rodriguez's plea of not guilty into the record, and we will set him for pretrial on May 10th. Mr. Rodriguez, so there's still a condition of your pretrial release we need to discuss. I show that you need to have an ignition interlock device put on your vehicle. So I want you to come back, talk with Mr. Waddell over here. That's gonna be a condition that you're gonna have to have on your vehicle. If you don't have that, then
I don't drive.
well, I want you to talk to him about that. And
Okay.
He'll let me know.
Yeah, Mr. Waddell knows everything, so. Thank you, sir.
Mr. Manning. Are you ready on, sir?
Judge, I was recently appointed to Miss Miles and Mr. Gould.
Say Miss Miles.
Yes, CR 22, 38, and 39.
Then what else do you have? You also have your
CR
James Johnson.
Yes, and then James Johnson as well.
Let's go call Mr. Johnson first. James Johnson, CR 21-294. Johnson.
Judge, he was here earlier this morning when you called the docket. I am unsure as to where he is now. I've been in communication with him. We received a new offer from the state. We also have a outstanding discovery issue that's the DA's office is working on resolving with the videos. But at this time, I'm unaware as to where Mr. Johnson is.
Deputy Phillips, will you go call in the hallway James Paul Johnson?
No response.
Thank you, Deputy Phillips. All right, the court's going to find that Mr. Johnson was ordered to be here at 9 a.m., that he was present when the docket was called. His case has been called now at 10:56 a.m. He's not present in the courtroom. His name has been called loudly, distinctly 3 times in the hallway. The court's going to find his bail to be insufficient. The court will set new bail, and we will set Mr. Johnson for an additional pretrial.
Judge, and I would ask if it's possible, if I can get him back by the 1:30 docket, if we could hold off on signing that warrant. I've been in communication with him, attempting to get him back. So if we just hold off till after 1:30, I make myself available to be here, see if we can get him here and get this thing ironed out.
Respectfully denied.
Okay, thank you, Judge.
And so let's go ahead and set him for pretrial. Do you have a preference on May 10th or 12th?
May 10th,
You get in custody.
May 10th, that's
May
fine.
10th. All right, we'll set Mr. Johnson for pretrial May 10th. If he's not in custody, then we'll just make an announcement that day. Lanaria Miles. Is it Lanaria or Lanaria? Lanaria, I'm sorry. All right, this is CR 2238, and Ms. Miles is set for arraignment.
Yes, Judge. I was recently appointed on both her cases. I explained to her the range of punishment, the charges that are against her. Her name is spelled correctly, and we asked, we make a plea of not guilty at this time and asked to be reset for pretrial.
All right, court will find that Ms. Miles has waived the formal requirements of arraignment. Court will enter her plea of not guilty into the record, and will set this matter for pretrial on May 10th. And Ms. Miles, before you leave, have you signed conditions of pretrial release yet? She has, okay, all right. Okay, good, thank you. You're free to go. Matthew Gould, CR 2389. All right, Mr. Gould, I believe a motion to adjudicate has been filed in his case. Mr. Manning has been appointed upon his request for indigent counsel. Court will set Mr. Gould in for the contested hearing docket on May 26th. If we reach an agreement, we'll take it up that day. If not, we'll do a contested hearing on his motion.
Yes, sir.
All right, Mr. Gould, you're still on probation, still under the order of the court, still have to report, comply with every rule. Just because they filed a motion doesn't mean you stop reporting and stop doing what you've been ordered to do, okay?
Yes,
And if you do that, then just fair warning, the state could go back and amend their motion and add additional charges to you in that motion. Okay?
Yes, sir.
All right, once you sign and get the yellow copy, you're free to go.
Judge, what date was that?
May 26th. Yes, thank you, Mr. Manning. Appreciate it, sir. You have jail cases today?
No, Judge.
No? Enjoy your afternoon. Say enjoy your afternoon. Mr. Ashmore still working with his clients?
Yes, Judge.
All right, I'm gonna bring in Miss Baker, Tiffany Baker, Miss Hoffpower. We'll see if Miss Baker is still with us. All right, good morning, Miss Baker. Can you see and hear me okay?
Yes, Your Honor.
Okay, thank you for your patience this morning. I tried to get most of my other attorneys who were present process here. All right, this is
No problem.
This is cause number CR 21327, State of Texas versus Sid Hoffpower, and we are set for docket call today. Ms. Hoffpower, can you see your attorney, Ms. Baker, there on the screen? You see her on the screen?
Oh,
There
yes.
she is.
Yes.
And you'll also see her here on the television. Okay, I'm sorry. Go ahead, Ms. Baker. Any announcement on docket call?
No, Your Honor, I talked to the prosecutor yesterday. We're still waiting on some documentation. I had to do a HIPAA release, so I told her that they told me it would be a couple of weeks before I got that information back. If we could just get another reset.
State, any objection to the request?
No, Your Honor, we're in agreement.
All right, Ms. Baker, are you available on either May 10th or May 12th?
May 12th, Your Honor.
May 12th? Okay. All right, Ms. Hoffpower, you are set for docket call on May 12th. That will be at 9 a.m. And Ms. Baker, I do want to bring to your attention that there are violations with Ms. Hoffpower's conditions of pretrial release. I show that she failed to report for March, and she's delinquent $240 on her pretrial release fees. Now, if that's attorney, we can remove Ms. Baker's retained, but show that she failed to report for March. So Ms. Hoffpower, I'm going to have you drug tested today. All right, so I want you to come up here and have a seat. And once we take the drug test, and that'll decide whether you go home today or you stay in the county. And so, Ms. Baker, you're free to be excused. I can give you the update on that, or you can stick around if you want to find the results.
Your Honor, on the check-in, is she physically checking in somewhere? Is that, I just wasn't aware that that was one of the things that she had to do was check in. Is it monthly?
It's as directed. It's usually monthly, but it's as directed by the pretrial release department.
Okay. I'll wait if that's okay.
Okay, yeah, that's fine. If you want to mute yourself, turn your camera off, then I'm going to call some other cases, and then as we deal with her, then we'll let you know.
Yes, sir.
All right, thank you. I'll make sure I update this paper. Mr. Viramontes, this is cause number CR 21374. Do you want the lecture now or after the hearing?
Now.
Now? Court starts at 9 o'clock. We're here at 9 o'clock. Mr. Schmidt's here at 9 o'clock. You're not here at 9 o'clock. I could easily just issue a warrant for your arrest, take you into custody now, we put you in jail. That way you're right where I need you to be when I need you. You understand that?
Yes, understood.
You understand that because Mr. Schmidt was here at 9 o'clock and he's asking me, Judge, please, for my client, do not put him in jail. Yeah, I saw him yesterday. I'm working with him. He's going to be here. Judge, please hold off. I'm doing that for you because I respect Mr. Schmidt and I'm extending him a professional courtesy on your behalf. So you should be in great gratitude to Mr. Schmidt. He could have easily walked out. I could have easily said, no, Mr. Schmidt, court starts at 9. He's got to be here at 9. I could be pretty hardcore and you could just go to jail. And I could not care about if you have a wife or you have kids or you have a job or a family. I could care less about all those things if I was that kind of person, but I'm not. Okay, so I'm giving you grace here. And so I expect when I tell you to be here at 9 o'clock, we're here and he's ready and I'm ready, that you're here. You understand?
Understand, sorry.
Will it happen again?
No.
All right. Mr. Schmidt, we're set for pretrial.
That's correct, Judge. We have no contested pretrial issues. We received an offer from state as this matter be set for a plea on that May 10th docket.
All right, court will set Mr. Viramontes for plea on May 10th at 9 a.m. Sharp.
10-4. Thank you.
Mr. Dixon, if you'll come on up, CR 21-211. We're set for docket call. Courts entertained the request for additional time from the defense, states unopposed. Mr. Adams is checking a reset date in June.
Judge, I'll be at a CLE in San Antonio on the 16th, so, but the 14th is open.
14th is open.
Yes.
Okay, we'll set Mr. Dixon for June 14th. I understand he's still coming from out of town, so we'll set it at 11 o'clock. Is that still fine, Mr. Adams?
Yes, Your Honor.
June 14th at 11. And Mr. Dixon, have you checked in with pretrial release and made any payments toward your pretrial release?
I can, sir.
You can? Okay, yeah, I want you to get the yellow copy and then meet with the pretrial release officers, make a payment, and then you're good to go. All right, Mr. Hawkins, can you see me, hear me okay?
I can't, Judge. I apologize. I messed up somehow and didn't get this docketed today. I apologize.
Okay, I understand. This is cause number CR 21398, CR 2251, State versus Royce White. We are set for pretrial. Do you have any contested pretrial motions, Mr. Hawkins?
I do not, Your Honor.
All right, there being no contested pretrial motions, we'll move this case to docket call, and we will place this in May. Do you have your calendar available?
I do, sir.
All right, are you available on either May 10th or 12th?
Judge, I have a jury trial, first degree felony jury trial starting in Kaufman County on May the 8th. I believe that's a Monday. And so I anticipate it going probably most of the week.
What about May 24th?
May 24th is good, Judge.
Okay, we'll set Mr. White then for docket call on May 24th, and that will be at 9 a.m. And Mr. White, make sure that you're here at 9 a.m., sir, when I call it. I almost issued a warrant for your arrest because you weren't here at 9 a.m. And Mr. White, after you sign to get the yellow copy, I want you to report the pretrial release. I show that you're delinquent on some of your fees, and I want you to meet with them and try to take care of that today.
Yes, sir. I'm working out of town, and I've spoken with Mr. Woodley. I'm going to pay the entirety of what I own right now after this hearing.
Good, as long as you checked in with them.
Yes, sir.
All right, thank you, Mr. Hawkins.
Thank you, Judge. I apologize.
No problem, appreciate it.
All right, bye-bye.
You have pleas on anyone?
I have Mr. Jackson, Your Honor.
Jackson's a plea. Jaquavian Jackson, CR 21361.
Judge, we have reached an agreement with the state of Texas on a deferred for Mr. Jackson. This is a possession of controlled substance penalty group 2. Just a moment, I'll sign the signature, Your Honor. This paperwork, Your Honor.
All right, Mr. Jackson, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. Jackson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is Jaquavian Antron Jackson, is that right?
Yes, sir.
And Mr. Jackson, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork, Mr. Jackson, that you've read and signed along with Mr. Ashmore that you do not understand?
No, sir.
Mr. Ashmore, do you believe Mr. Jackson to be competent today? And have you explained to him his legal rights and the advantages and disadvantages of the deferred adjudication?
I do believe he's competent. And in fact, he is competent, and he's 18 years old and made a mistake, and not a small one, and he's aware of that. And I've told him that we've all been, at one time, despite all the gray hair, we were all on this chapter in life. And I've explained to him that he's got an opportunity to get his rights as a citizen back, to be fully restored under the Constitution of the United States of America upon successful completion of deferred probation, and also the ramifications of, bless you, of a mess up, right? Which includes the sanctions that are in those conditions of probation, up to a motion to revocate and adjudicate his guilt and expose him to the full punishment range of 2 to 20 years in the Texas Department of Criminal Justice. So we've covered that, and we are good with the deal, and he wants to move forward and close this chapter in his life, Your Honor.
And do you believe that he understands all of his legal rights as they've been explained to him?
I do, Your Honor.
He has the conditions of.
I do. They're in my, may I approach?
You may.
Thanks, Judge.
All right, Mr. Jackson, I see that you have been charged with a second-degree felony offense of possession of a controlled substance in penalty group 2, greater than or equal to 4 grams, less than 400 grams. A second-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 20 years confinement in prison, and a fine of not more than $10,000. Do you understand that full range of punishment?
Yes, sir.
You understand that if I approved your plea agreement today, which is the court would entertain your plea of guilty, the court would accept it, the court would defer a finding, that means court would not find you guilty today. The court would then place you on community supervision for 3 years, order you to pay your fine, court costs, reimbursement fees, your restitution. The court does all those things, and later you get on probation and you violate. The state can file a motion to adjudicate your guilt, that means to convict you, bring you back to the court. They put on evidence that proves to me that you violated your probation. Court could revoke your probation. I could convict you of this offense, and I can assess your punishment anywhere between 2 all the way up to the maximum of 20. Do you understand that?
Yes, sir.
You understand that being the plea agreement and that being the range of punishment, understanding both those things, you still wish to go forward?
Yes, sir.
All right, Mr. Jackson, then how do you plead to that offense?
Guilty.
Are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court accepts the defendant's plea of guilt at this time. Mr. Ashmore, any objection to state's evidence?
No, Your Honor.
State's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
All right, court has reviewed the evidence. Court finds that there is sufficient evidence to convict Mr. Jackson of this offense. The court will follow the plea agreement in this case. Court hereby defers a finding of guilt on the second-degree felony offense of possession of controlled substance, PG2 greater than or equal to 4 grams, less than 400 grams. Court places Mr. Jackson on 3 years community supervision, orders him to pay a $2,500 fine, $180 restitution, $785 reimbursement fees, $290 court costs, and the court dismisses under section 1245 DA 2021-512 possession of marijuana less than 2 ounces. Mr. Jackson, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with the deputy. After that time, you'll report to your left to the probation officers. Who else you ready on?
Ms. Harris?
Alicia Harris, CR 21359. Ms. Harris is set for docket call.
Yes, Judge, we're gonna ask the court to reset to plea.
All right.
We've got a new plea offer. Conviction of state jail felony offense as charged, 3 deferred and a $1,500 fine. My client wishes to accept that.
Just for the record, it's not for 3 deferred, it's for 3 straight adjudicated probation.
So it'd be a
Oh,
conviction.
that's my fault. Yeah, excuse me.
So it'd be a conviction with 3 years community supervision.
Yes, sir.
What would this?
Yeah,
What would this sentence be? So 18 months probated for 3.
Yes, sir.
That's fine.
Yes.
And your client's wanting to accept that and set this for plea.
Yes.
All right, court will set Ms. Harris for plea before the court. Are you available? If I set you, yeah, I have numbers. Are you available on either May 10th or 12th?
Can I confer with the state? Okay. Judge, I'm here on the 10th, so that'd be much appreciated.
All right, Ms. Harris, court sets you for May 10th at 9 a.m. Once you sign, get the yellow copy, you're free to go.
Yes, Your Honor, thank you.
You're welcome. All right, who's next?
Mr. Keenan, we have an arraignment.
Jonathan Keenan, CR 2229.
Judge, I've been over the indictment with Mr. Keenan. He understands it's a 2nd-degree felony, aggravated assault with a deadly weapon. He understands the allegation is that he knowingly, recklessly, he's alleged to have intentionally, knowingly, or recklessly caused bodily injury to the victim, Thomas Simpson, by hitting him with a blunt object. And that blunt object is a golf club. During the commission of this assault, it's a punishment range of 2 to 20 years. He's authorized me to enter a plea of not guilty and negotiate further with the state or obtain discovery, which the state shared with me yesterday. We do have a current offer of 10 TDCJ as of yesterday when the state shared the paper discovery file with me. I'm going to ask court to reset this.
All right, court finds that Mr. Keenan has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. We'll set this matter for pretrial on May 10th. That will be at 9 a.m. And Mr. Keenan will need to sign conditions of pretrial release. So once you get the yellow copy, come meet the pretrial release officers. And these will be conditions on your bond that you'll have to comply with.
That's supposed to be about this. There's already something else that this.
Judge, we're going to plea Mr. England at, if the court would entertain it at the 1:30 docket. Can we just report to the Justice Center at 1:30?
Is Mr. England going into custody?
He's not, but we just couldn't get everything done in time this morning, and it's my fault because I had an appearance in Rockwall.
I'm not sure that they'll let him in the back. So he'll just have to come here. and
Come here.
You'll have to either come here first or go over there first.
Okay, Judge.
I'd rather you go over there first.
That's
They can
fine.
Take care of the jail and then you can just circle back through here.
Okay, thank you, Judge. We'll do that. Okay, Mr. England, you understand? 1:30 here, we're gonna have you pick one around. 1:30 here. And just hang out, Paul, for a second. Thank you. Judge, that's all I have for the moment.
All right, well, let's go ahead and announce on Tad Michael Russell. He's in custody in Henderson County. This is cause number CR 21-339-340. Set for docket call. Of course, confirmed. Mr. Russell is in the Henderson County Jail, and the court will reset this for a status of custody and for docket call. We'll reset this on May 10th.
Okay, thank you, Judge.
Who can?
Just give us a moment.
They can do it. Okay, so Mr. Woodwag, apparently we're going to try to Zoom Mr. Russell from the Henderson County Jail this afternoon on our Zoom docket. So you can scratch through the May 10th reset. So Mr. England will be at plea at 1:30. So that just leaves us Mr. Flores. Yeah, how's that?
She did. This is gross. This was in for John.
I've got unfortunate news for you, Pine. No, we're not on the record. I'm just gonna let Ms. Bicker know. So Ms. Hoffpower tried to falsify her UA today. Ms. Burns is going to show you what was discovered. Your client attempted to give a, you're not in front of the camera. No, come right here. It's right here. It's this little camera right there. See everything. So now lift it up a little bit. So that's put it down. That's a little canister. It's a little canister of urine. She borrowed a safety pin from one of our staff members up here in an attempt to pierce it. So she had that in her body. She was going to take that safety pin, pierce that. So of course, my community supervision officer was alerted to that. And she also admitted to an Adderall and marijuana. Adderall and marijuana without consent or without permission. So what we could do is we can have a hearing. I can put the officers on, or I could just find her bond insufficient and we can set it for a hearing later. Either way, I'm going to keep her today for violation of pretrial release.
Yeah.
You mean let you think on this a little while? So typically what I can do is I can bring her back out here and I would announce all that to her. And I would have an officer testify. Did she admit to she signed an admittance to the marijuana. What was it? Adderall. So usually that's how I would conduct that hearing, but I just want to give you the heads up. So we can go ahead and do that, but I just want to give you a heads up what was coming. Okay. All right. So I'm going to deal with Mr. Ashmore. He's got another client and we'll call Ms. Hoffpower. Okay. You can go ahead. All right, Mr. Ashmore, are you ready on Mr. Flores?
Judge, I'm ready on Mr. Flores. He's here before the court.
Hang on, let me call the number here. This is cause number CR 21-165, CR 22-18, State versus Marshall Flores. Mr. Flores, you're fine right there where you are, sir. All right, Mr. Flores is set for pretrial today.
Yeah, Judge, he is. We don't have any pretrial motions filed. We don't believe we're going to be bringing any. I'm asking the court to reset this for a docket call. We did just recently, and recently being on 4/11/2022, receive a plea offer from the state, 12 TDC on the 2021 case and 1245 the 2022 case. I'd like an opportunity to further visit with my client about all of this, including any defensive theories we may have, and just reset this for a docket call, Judge.
All right, court will set Mr. Flores for docket call on May 10th at 9 a.m.
Thank you, Judge.
Mr. Flores, once you sign and get the yellow copy, you're free to go, sir. You're welcome. Mr. Ashmore, I was going to tell you that. So Mr. Russell, we're going to zoom him in from Henderson County at 1:30. So while you're,
I'll report here since we got to do.
we're over there. We're over there. Whenever we have Henderson County ready, I'm just telling you for this morning, Mr. Russell will zoom in
Okay, thank you, Judge.
at 3 o'clock. you have on this morning's docket, Mr. Ashmore?
Yes, Judge.
All right, Ms. Hoppower, come on over here in front of just stand right up here in this little blue square. All right, we are back on the record, cause number CR 21327, State versus Sid Hoppower. We previously called the case and the court has set this for docket call on May 12th. And the court ordered Ms. Hoppower to submit to a urinalysis exam for a couple reasons. One, she was late to court today, and two, she failed to report in March as a condition of her pretrial release requires her to do. Officer Matura, if you'll come over here, Officer Matura, so Ms. Baker can see you. There we go. This is Officer Rachel Matura. Officer Matura, did you conduct the urinalysis exam of Ms. Hoppower as requested by the court?
I conducted the attempt.
And during your attempt to conduct, were there any issues? And let me do this. Let me have your right hand. I'm going to swear you in. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you're done.
I do.
All right, go ahead.
Yes, Ms. Hoppower tried to falsify her drug test.
Okay, how so?
She had a device in her body and tried to poke it with a rather large single pin.
And the device had or has some type of liquid or whatever to attempt to try to provide a sample?
Yes, sir.
Okay, and did you confront her with that?
I did.
Okay, did she make any admissions?
She did.
What did she say?
That she did, in fact, try to falsify, but when I asked her, did she have a device, she said no because it had already fallen out. So
And you've recovered the device, is that correct?
it is.
And were there any admissions made regarding the use of controlled substances?
She admitted to using marijuana and Adderall without a prescription.
All right.
I had a prescription.
That's Ms. Hoppower, no. Because Ms. Baker's not here, I want you to just remain quiet until she instructs you to speak, or it'd be in your best interest not to say anything at this point. Ms. Baker, do you have any questions for Officer Ventura?
No, Your Honor.
Okay. All right, thank you, Officer Ventura. State, do you have any questions for Officer Ventura?
No, Your Honor.
All right, thank you, Officer Ventura. All right, Ms. Baker, unless there's an objection, the court would move to determining whether Ms. Hoppower's bail is insufficient in this case for violations of conditions of pretrial release. Would you like any argument at this time?
No, Your Honor.
Okay. All right. Court is going to find that Ms. Hoppower has violated the conditions of her pretrial release by attempting to falsify the urinalysis exam and also admitting to the use of controlled substances without a prescription. Court hereby finds that her $50,000 bail is insufficient and increases her bail to $100,000. That will be conditioned on it being a surety or cash bail. And Ms. Hoppower is ordered into custody at this time.
Your Honor.
Thank you, Ms. Baker. I appreciate your patience. I'm sorry it's taken a while.
No worries, Judge. Thank you.
We'll see you soon. Yeah. But I believe that concludes this morning's docket. Just for the record, Mr. Matthew England will be recalled at 1:30 for plea. Mr. Ted Michael Russell will be zoomed in from the Henderson County Jail at 3 p.m. I believe that everyone else that did not appear at 9 eventually appeared and made an announcement. So the court will stand in recess until 1:30, and jail doctor would call from Van County.